My father, Charles Schwartz, was a second-generation Washingtonian. He spent his whole life here. He ran a business, raised a family, served the community in many ways, including the police department and the fire department extensively. On October 1st, 2008, at the age of 85, he was struck by a car and killed while he was crossing Connecticut Avenue in the 5000 block. As you say, that was in front of Politics and Prose. It was 12:15 in the afternoon. He had just stopped at the bank and was going across the street to pick up a sandwich. So what we know about this incident, we know from our conversations with the police and the assistant U.S. attorney who handled the case over the course of a year. My father was not in a crosswalk. There was no evidence that the driver was speeding, nor was he intoxicated. They did a quick test on the scene. The driver never applied his brakes, nor did he swerve to try to avoid hitting my father. And as you said correctly, the crash reconstruction showed that my father had already finished crossing Connecticut Avenue almost entirely. He had passed directly in front of the car. And so apparently just the slightest maneuver or easing up on the brakes would have avoided the collision. The driver said he never saw my father. Though the circumstances strongly suggested that the driver was distracted, at the scene there was no cell phone confiscated or identified. The cell phone number was not recorded in the report, and the driver did not cooperate, would not answer questions regarding this. At a certain point, he called his attorney, and his attorney said not to speak. And no one at the scene saw the crash before it happened. They were witnesses afterwards, in the aftermath, but no one could be found who saw the driver before the actual collision. Because there was such a strong suspicion that a cell phone was involved, MPD launched an investigation that turned out to be unbelievably complicated and took many, many months, probably about 9 months. They eventually learned that the driver had in fact been on his cell phone, making a series of calls prior to hitting my father. The assistant U.S. attorney presented the case before a grand jury, seeking a charge of negligent homicide, I believe, and did not get an indictment. So the case ended there. The bottom line for us is this. We absolutely believe, based on all the evidence, that a driver who was distracted by using a cell phone in violation of D.C. law slammed into my father, killing him, and then walked away without even a ticket. This is what does not sit right with us and why we're here today. So we learned a lot of things in the course of the investigation. I want to focus on the distracted driving issue, and secondly, this issue of how we can get a case through an indictment and an actual conviction where it's appropriate. But first, I do want to say that we had, all through the process, a very good experience with members of the MPD and the Assistant U.S. Attorney's Office. Joe Diliberto of the Major Crash Investigation Unit was fabulous. And he just kept persisting in the case, and John Soroka with the U.S. Attorney's Office was terrific. And I also have to say that our experience at the Medical Examiner's Office working with the Wentz Center was really meaningful. I think they either have been axed from the budget or are about to be, but they provide service at the Medical Examiner's Office, and they were just, as horrible as that was, they were just incredibly fabulous. Regardless of what new bike lanes or signage or infrastructure are created to protect pedestrians and cyclists, if drivers are not paying attention to the road and their surroundings, they're going to continue to hit people. The body of evidence is growing that cell phone use is as dangerous as driving with 0.08 blood alcohol level under the influence, and texting is at least twice as dangerous. We think we really need to re-examine our distracted driving law, which was passed originally in 2004, and I know it's been updated to, it's been tweaked a little. The penalty is $100. We think we could look at graduated penalties, larger penalties for second and third offenses, and even adding points, if we look at this as dangerous as drunk driving. We have this in the law. It says that first-time offenders get a waiver. We understand you just produce a receipt and you can get out of your ticket. And the police have said that's kind of an easy one to get out of. And that was to kind of give people time to understand the new law. And then something that we found very difficult, the law requires that MPD fill out a report and at the scene say if a cell phone was present in the car and whether it may have been a contributing factor in the accident. Do the police really have the tools to know if a cell phone is involved? In my father's case, the driver did not volunteer the information or even give the correct cell phone number at the scene of the accident. And I don't think the police have the ability to yank it from them. I'm not sure. And that created a lot of problems, and it was really difficult. It's not like TV where you just find out if someone, you pull the records. It was a very long process. So I think what happens at the scene and the ability, some people have suggested this notion of implied consent as a way to say if you're driving, if you're involved in a fatal accident or hit a pedestrian or a cyclist or in any kind of accident, you voluntarily give your cell phone up, or at least give the number. Then there's the larger issue in what we do in the event of when a distracted driver actually runs into a pedestrian or a cyclist, leading to a serious injury or death. In my father's case, we do not believe the driver set out that day to kill someone, but he apparently made a conscious choice to use a cell phone in violation of DC law. It makes no sense that we create laws ostensibly to protect people, and when the absolute worst happens, there's no appropriate penalty, or the burden of proof is too high to impose a penalty. We need to address this.
Can you just kind of summarize what's
Yes.
left?
I mentioned a couple states that are doing something interesting. I did want to mention that in New York City recently they passed L's law, where a similar type of incident happened. A young girl was hit by a vehicle that was backing up through a crosswalk into an intersection, and there was no penalty. And so L's law says that if a driver hits or seriously injures a pedestrian while committing a traffic violation, their license is suspended for 6 months. It's not a jury trial involved. So I think, and also after talking to the U.S. Attorney's Office, that we need to look at lesser, I agree with previous testimony, that we're not looking for people to go to jail for many, many, many years in most of these cases, but there needs to be some appropriate penalty. It's not okay to be let off without a ticket even. Thank you.